part of the symposium. And of course, you're going to come with some interesting insights and perspective, which I know. So please, what we'll do is, a little bit about yourself, as much as you want to, and then we'll go into the symposium.
Well, are we on live? Are we live?
Yeah.
So first of all, thank you, Vikram, for looping me in. What you are doing is really fantastic, because you're trying to bring different practitioners, mediation practitioners, mediation academics all together. And very broadly, you have structured it, rather, and let them bring out whatever is there in their mind. And so this is an initiative of capacity building, as well as it is also trying to promote mediation as such. Now that's very laudable, not just noteworthy, but very laudable. I would say thank you very much for doing that. And now coming into who am I and why I am there. Of course, I am a legal practitioner and at the same time a mediation practitioner. I have certain specialization, area of specialization that caters to commercial law practice, I would say. And I'm not going to getting into that details. As far as mediation is concerned, I am like Vikram. I also love to make sure that this is picked up as a preferred mode of dispute resolution. So that is, I will say, and one can go back and look into my LinkedIn page as to more details of what I do, and not waste time on that. So far, what I would say is that I am quite fascinated the way it is fascinated the way you have structured, like you have posed some certain question as to how, what, when, where, which, who, why, and that means that one can be very flexible as to what it means and how you interpret it. It can be completely different for different people, but it is all stitched together in some way or the other. And there, what I suggest is that I am sure that Vikram might have a way of something in his mind, a way of thought, as when he talked about how, what, when, where, which, why. But I would shuffle this hows and whats and whens and wheres and try to stitch it together in my own manner. And I'm sure that Vikram would give me the license to do that. But now, when we are talking about mediation and coming into all this whats and wheres and hows and whens and stuff, what Vikram has managed to do is not just stitch together a garland of all mediation practitioners all over the world, but also, and academics, but also pushed us back to our own hometown and try to see, to go back, introspect, and discuss internally as to what needs to be done, where are we doing things right? And there, I have to thank Vikram, because it led me to discuss internally with my my policy senior policy advisor B.N. Sigda, who I think is online, and he brought in quite a number of very, very pertinent questions, which will lead and raise areas that perhaps I would have missed. So that is that. With that, we look into mediation. When we talk of mediation, Let me pick up the what and why first. When we talk of mediation, what comes to our mind? And I focus on the what part of it. When we talk of mediation, immediately what comes to our mind is mediate, which is an intervention. A mediate, when you talk of mediate, you talk of mediate between parties. Obviously, when you talk about mediating between parties, you obviously understand, or obviously there is an understanding that there is dispute between the parties. So if there are disputes, there may be two parties, there may be more parties. There's a dispute between the parties. And so mediate obviously would have a result, and the result is dispute resolution. And the dispute resolution becomes the primary importance of the parties. And there, the question many people would ask that why, if that is the main dispute resolution, if this can be one of the main dispute resolution modes, then why? And I bring Vikram's why now as to why do we call it alternate dispute resolution? Why should it be alternate dispute? Well, a very, very, very pertinent question. We will see that, of course, mediation in different forms have been there for a long time, and there is history. But at the same time, we will see the rights-based dispute resolution in a structured, established courts manner has been the mainstream mode of dispute resolution. When we have the rights-based mediation and extending to certain extent on the contractual side of the arbitration, then the others, where you got the arbitration, conciliation, mediation, all these are pushed to the alternate dispute resolution. Well, one can very well ask that why it is pushed to the alternate, because people are more comfortable with the rights base, and they have pushed towards the rights base, and the ecosystem has been built focused more on the rights-based approach. And we see that the mediation and all the others have been put to the alternate dispute resolution. And then the obvious question is that if we have a rights-based approach, why should we go? Another why comes in as to why we should have an alternate mode of dispute resolution, like mediation. Why? But there are many advantages, and also because I understand many of you who have logged in today are mediation practitioners, and this will be obviously you are aware of it, but there will be many who are not. So I would say that when you look into mediation, from my perspective, one very crucial, important focus or the salient feature is it is confidential. So the confidentiality is very, very important. It is less intrusive. Both the parties are independent, both the parties are there. It is they would directly engage in the negotiations between settling their problems, and there the mediator comes as a third party neutral. So the point is, it is more engaging. So obviously there are less procedural issues. If you go to a court system, there will be a filing of the complaint. They will be looking into the registration of the complaint. The registry will look into the procedural issues, where there are technical flaws, will go give it back, you correct it and send it. So the entire procedural issue can take a long time. So here what happens is you're going into less time. It is less time consuming. Obviously, if it is less time consuming, it is also less expensive. So these are some of the areas we see that for which we have the answers to the why alternate dispute resolution like mediation. Then coming to the next question, I would say the next question as is who followed by how followed by who. Now, when I say how, what do I mean? How mediation is undertaken or conducted. Well, as I said, it is not a rights-based approach. It is an interest-based approach where the parties to the conflict are directly engaged in settling their dispute. The third party neutral facilitates them in coming to an understanding as to what their interests are and linking them. They come and try to link them in a manner facilitating them to reach a resolution of their dispute. And in fact, it is not actually, if you see, it is not a sort of alternate dispute resolution, but an appropriate dispute resolution. Because why I would say appropriate? Because here what happens, the decision as to the settlement of the dispute is not pushed onto by an adjudicator. When it is done by an adjudicator, there obviously, for whatever reasons, that there is one party said, yes, your right has been breached, and on the other party's right there would be a grievance, and the party would desperately try to go to the upper forum, the appellate forum, and go on till the person is stopped. So actually, the adjudication is forced onto the parties, and the losing party will accept it at one point without going further. But here what happens, it is a win-win situation. Both the parties agree, both the parties finally accept it and say, okay, fine, we are settled. Now, the question comes is, who is this third party neutral? Who is the mediator? So the question comes down to who the mediator is. And yes, the mediator is a third party neutral. What do we mean? What do I understand by when I say third party neutral? He's a qualified, he's a trained professional who will be participative in the negotiation between the parties, will be collaborative, trying to collaborate, maybe at times for the practitioners, they will know, we would be doing it separately with the parties, would be doing jointly with the parties, all what has to be done to make sure both of them come and remove their misunderstandings, remove their dispute, remove their contentious positions, and remove the positions and look at their interest and settle the matter. So there what happens that the mediator is neutral, is absolutely neutral, is balanced to exercise his or her authority, would not push one way or the other. And then when we see the difference between a conciliator, would not try to influence the parties. So that way it would be very, very balanced, would not even remotely try to be an adjudicator. So that is what happens. And that is when we talk about who is a mediator, that is a mediator. Now, if you look into a different question altogether, which, where, and when I say which, where, I bring in a different sort of connotation as to which is the statutory framework that governs mediation. And of course, we are sovereign, so I would consider India. So which is the statutory framework which governs mediation in India? Now, that's a tricky one, because as of now, we see the Arbitration and Conciliation Act 1996, as amended in 2021, is the statutory framework. Now, very interestingly, the statute does not specifically address mediation. It talks about conciliation, but it does not have mediation. What happens quite often is people try to, when they do the mediation, they draw the settlement agreement under the conciliation, as if it was a conciliation. Now, there is some sort of an anomaly which needs to be addressed, but this is the framework. And now coming into the where part of it, where does India stand in the international governance? What is the international governance? When we talk about international governance, concurrent international governance, we would say that the International Agreement on Mediation is the United Nations Convention on International Settlement of Agreements, which in common parlance, we call it the Singapore Convention. Why? Because it was signed in Singapore on the 7th of August, 2019, and came into effect on 12th of September, 2020. India is, if you're question comes as to whether India is a signatory. India is a signatory with 53 other countries, but yet to ratify. Now the question is, I would say, when should if we have, when should we ratify? When should we ratify the Singapore Convention? Now we will ratify when we have a municipal law. When will we have a municipal law? Well, we will see when we will have a municipal law, but we can, in between now, what we can do is we can look into what are the efforts that have been made to go into the implementation. The efforts that have been made is that India has introduced a mediation bill, which is called the Mediation Bill 2021, and we can go into the details of it. But I would rather like to have a bit of discussion. So what I would say is some of the salient features would say it defines mediation, but interestingly includes conciliation into mediation. And then there are some other salient features like pre-litigation mediation is mandatory for civil and commercial matters, other subject to if the parties do not opt out. And then they're introducing online mediation. We have seen it as, the mediation bill has picked up from the experience during the COVID, and there is online mediation, provision for online mediation, provision for community mediation, and there is obviously, they have structured, or there's provision for a mediation council of India. Now it's the governing, it will be a governing body. How it will be structured, all the minute details will come up later, maybe through the rules or some notification of policy. I am not sure at this moment. But then, of course, which is very, very important, is the mediation settlement would be considered final, binding, and enforceable as a decree in a court of law. So these are some of the features. Now I come back to what, and why I say come back to what. I would say that what happened after the bill was placed before the public. There are a lot of comments which went on as to what are the areas that common people had thought that it will not work, what are the areas that might need to be amended, and the bill was sent to the Parliamentary Standing Committee on Personnel, Public Grievance, Law and Justice. And what did coming to the what did the Standing Committee report say? Well, it said a lot of things, but among different things, it focused on one thing, that the time-bound nature of the mediation, which has been suggested at 180 days, has been reduced to 90 days, or proposed that be reduced to 90 days with an extension of not another 180 days, but 60 days. Well, we see that there, if you look at the court system of the delays, perhaps with that mind, someone has drafted 180 days as a good time schedule or timeline. But if you look into mediation, you cannot prolong for so long, because it is a pre-litigation mediation, and after that there may be a litigation. So it is better to bring it down, and perhaps the suggestion of 90 days is very, very delicate. Then we see that it says that it mandates pre-litigation mediation. Now the concept of mediation is voluntary. Now, for that reason, or maybe some other reasons, the Standing Committee has suggested that let it not be mandatory, let it be choice of the parties. And then we see that because it is covering different statutes, consumer protection, etc., there are intermingling or interfacing of different governing bodies, which can be a problem. So it has suggested that Mediation Council of India be the only governing body. And then, of course, there is, as I started my discourse, saying confidentiality is a core area of mediation. It covers confidentiality, but doesn't say if there is a breach of confidentiality, what will happen. So it has considered or proposed, recommended that there is certain provision for penalty or other provision, appropriate provision for breach of penalty. And then another very crucial point is that it needs to implement Singapore Convention. And in the Singapore Convention, one of the crucial issues is enforcement of cross-border mediation settlement. And there we see that the bill is completely missing on that. Now we go back to what and say what else. You would say, if you look into the what else is there in the mediation bill, which perhaps the what you call the standing committee have not looked into in detail, is that one very, very crucial thing that I see is the qualification of a mediator. It says that there are four, a mediator to be able to mediate on pre-litigation civil and commercial matters would need four qualifications or four registrations. One with the Mediation Council of India, which I understand is very reasonable, but then also be empaneled with the court annex mediation center. Then also be registered with the recognized mediation service provider and also the legal services authority. So now, I mean, I think this multiple registrations are superfluous, and it will be very cumbersome for a person to go and mediate. And perhaps when you have a Mediation Council of India, that should be a primary, and it should be that either the Mediation Council of India or any of the others. I don't know. So the suggestion, I would say that just if one is registered with the Mediation Council of India, it should be fine. And then, and as I earlier pointed out, conciliation has a sort of adjudicatory flavor. The conciliator can influence. So it needs to, I mean, if we want to work on the conciliation part of it, restructure, reframe, then the Arbitration Conciliation Act can be revised, amended appropriately to focus on the conciliation part, and it completely it be removed from the mediation. That is another area that I would suggest. And then the exercise of the court jurisdiction. It has completely taken away the choice of parties in private mediation. Now, because if say that wherever there is a court jurisdiction which can apply, the court will exercise jurisdiction. That takes away the possibility of private jurisdiction. Now with that, I mean, there are many more. We can go on and on and on. So with that, I think we still have around 10 minutes. I will go back to Vikram.
Don't worry about time. Don't worry about time, because the session after yours, that person has lost his voice. He's not going to be coming in. So you have enough time, and all these interesting points that you have raised, all these interesting points need lots of discussion. And
yeah.
Vigyana also, we have to get him also later in. Yeah.
So thank you. And as I mentioned, I see Sigdar very much there. I was telling Vikram as to how we managed to look within ourselves and discuss this issue. And I'm very much thankful to Sigdar for his valuable inputs to whatever I have said. And thanks to Vikram for connecting and making us go back on that.
Sigdar, you want to tell us about yourself, please? A little bit about yourself. Begana, you.
Can you hear?
Okay. Maybe I think.
I'm not sure whether you can hear.
But I tell you what, I mean, one thing, Santanu, what I've tried to do, and which came from this World Mediators Conference I did last year, that the adversarial, whatever system that we've got into, the terminology has come into it, into our, what we call, or let's call it alternative dispute resolution, which of course I'll discuss. The terminology has come from there. So there was one discussion on terminology and mediation, where there was Ginny, she's from the US and works in community mediation, said we are creating words which do not connect to the adversarial. So instead of parties, we use participants. Instead of course, that opening statement part, we use orientation. So we're trying to create an atmosphere where this is not adversarial. You're all coming together to in whatever way, collaborate. So that I like that terminology aspect. The other thing that you said about the alternative dispute resolution and the fact that we have to call it alternative, and I had a discussion, a whole symposium on colonization, decolonization, and mediation, only because the colonial system made that mainstream. And then what was there before that? So
Absolutely.
there were two symposia. One was mediation in our culture and traditions, the other was indigenous people and mediation. So let's find out
Absolutely.
what was there. So but only there, what I was telling everyone, be careful, don't say that it was in our culture, it was always mediation, because there was arbitration happening there also. So we have to be careful there and find the right word that people connect with mediation, so that there is no confusion. Because in India, what has happened? Even the Supreme Court training manual says panchayat and mediation connects the two. And I have discussions with villagers, and they say that panchayat is a decision-making body, and
It's
they
an
are
adjudicatory body.
yeah, and they actually
At the most, you can make it similar to arbitration of sorts.
exactly. And to the other extent, they say that if whatever they decide, if people don't follow it, they even bash them up. So their connection with your
absolutely. It's not even conciliation. There is a penalty aspect of it, whether it is bashing them up, or whether X will give so many number of counts to the other, or they will be isolated in their home for 7 days, or whatever it is. I mean, it can be bashing up, it may not be bashing up. So there's so many things, but there is a penalty factor, which
so we have to be really careful what word we connect people with, because the theme of that symposium was that the people may not be familiar with the word, but they're familiar with the process. So let's connect them to the process, and when we connect them to the process, let's connect them to those people who do that process, not the people who are doing the other adjudicating part of it. Then these people get to be identified and valued. So I'm just giving you the background, because there have been so many events and everything that I've done. Definitely it'll be difficult to even keep a track. So this is the 8th symposium. There've been 7, each a chain I've tried to create, because there are topics which I thought, like neutrality. I mean, like you said, neutral. I had one symposium on neutrality and mediation, because that by itself is debated. And I mean, people who've been practicing for years have come in. Bernie Mayer is someone who's been has written about neutrality for years. So he's written, last book is Neutrality Trap. So in that sense, there is lots we have to debate also. So I said, let's discuss that. But the one reason, I mean, the fact that the inefficiencies of the court system, and people then, because of that, if they are going into mediation, because what is mediation? And that part of it, a voluntary process is what we say. But is it really voluntary when the inefficiencies of the court system in some way dictate the terms for the people in the process, because there's a gun on their head that cost and time is on the other side. So inefficiency of the court connecting to mediation, and whether that is mediation itself, because it's not self-determination, because there is an external influence, which is the court system. So that part I have had discussions on. Background I'm giving you because, Shantanu, I'm sure you won't get time to watch. There are now almost 550 videos there, which means hundreds of hours of content there. So I will, but you want to, Sigdar, are you with us? You can hear us?
Sigdar, can you hear us?
You want to?
Yes, I can hear you.
You want to introduce yourself? Tell us a little bit about yourself.
Okay, my name is Vikram Sigdar. I'm from Kolkata. My background is banking. 17 years I've worked in a bank. Now I am the senior policy analyst here in the ex-levy chambers.
Perfect. So thank you. And Shantanu was telling us when you were not here that you've done a lot of work with him, and you've the background research part of it. So you've, I mean, taken up that whole mediation bill and all that. So we'll have a discussion on that, because it's important. But I think he has a signal issue, because it seems to be frozen.
Yeah.
But Shantanu, the other word that always gets connected when mediation is spoken about and mediators are spoken about is training, which I criticize so much, because for me, let's look at it in the India concept. We say that, okay, 1.4 billion people, but 1 billion people are in villages. And whenever I think of legislation or anything to do with mediation, we have to start from there, because these are people who actually are, in a way, disconnected or even, I mean, inconvenienced by the court system, because the Supreme Court being 2,500 kilometers from someone's house or someone's village in one part of India, I think, I mean, we might say that there is justice being done, but is that's whole debate. We won't get into that. But I'm just saying that from that end, I always
justice may be done. That's may be correct, but there is a question mark because of the quantum. The quantity that is required, or the numbers that are required, and the numbers that are met may not be considered, in the sense it might be balanced. So the demand is always higher than what we have.
Yeah,
so,
because I have had a lot of, I mean, comments I've made on this aspect, because I always say that the fact that the court system and mediation being connected is because the inefficiency is there. And of course, like you said, the numbers on that side. And because of that, the word gets connected to the court system, but we have to put it across that this has nothing to do with the court system. It's a process separate to it.
absolutely.
And has, I mean, the whole thing has to be, I'll get to that part of the fact of the bill connecting to the judiciary part of it. So I always look at legislation or anything to do with mediation, keeping in my mind that there is a village somewhere, and can we legislate in a manner that we are empowering them. And that's why I'll come to the conciliation portion of it, because that's something I feel from my side. I feel that, first of all, it's a simple legislation and people would understand. And the background is that we've adopted the 1980 conciliation rules of the UNCITRAL. And today, even 45 years later, almost 45 years later, the whole concept of mediation itself is not understood. So it does put out in some way, in a simple way, what is mediation, how you have to go about it. Of course, people look at it and say, look, there is an active role of the conciliator. But when I look at the provisions, there is always a may do this, because always in any kind of process of mediation, there will be this whole debate of evaluative, facilitative, because some people would say it is only a facilitative process, but some people would look at it as an evaluative process. So it's worded in a manner to take care of any kind of process, because no one should tomorrow say that the conciliator or mediator suggested something. It's available in the provisions. Yes, may suggest, because we always have, I mean, I've also put down in my post that I put out that the word themselves, the UNCITRAL has clarified now. We were using conciliation because at that time that was the word they were using, but we have moved to mediation now, but there is no substantive difference in the two. And if it's mediation word has become more popular. So I always look at it as a law on mediation in India. So, I mean, although on the other side, people say there is no law, I always say there is a law. Go into the background. We adopted conciliation rules, which is UNCITRAL's rules. We have a clarification today from them in the mediation, the model law that they put out, clarification there. So I am saying we have a law, but only thing, like you said, do we need to tweak it? What if we have to tweak it? So we have a structure. Let's look at this.
Here I have a point. Typically, if you see the court annexed mediation, or those that we are calling mediation, I have seen most of them to be conciliation. They are not mediation, and very few of them where the mediator actually acts very neutral, in the sense we can and facilitates. It varies, because quite a number of times, if not most of the times, they are, many times, they are former adjudicators. And then the rest, when they are not former adjudicators, they are litigators. When you have litigators coming in, there is that I win over you through my client wins over you. So that mindset is there. Now, with that mindset, you can tweak that mindset and bring into certain extent to conciliation. But that's my understanding and that's my belief. But that bringing into mediation is difficult. Now, if someone wants to merge mediation and conciliation, as you're saying, as to one, then they'll say that where the mediator may be influencing and not be third-party neutral and be a little bit of conciliator sort of, then there is another discussion that can happen on that, and we can have that sort of a hybrid system where mediation and conciliation are merged together, and it is up to the mediator or the conciliator to decide whether it exerts influence or not. So that
Yeah,
very
no,
well.
but from my side, look, I am looking at conciliation and mediation as the same thing, only because where we have picked up this from, those people themselves are saying it's the same thing. It's just a change of the word that we have done. Because I'll tell you where the problem lies. The problem lies from our conciliation provisions, the role of the conciliator. This part is what sometimes people, because look, interpretation of statute, sometimes what happens is that for convenience, this may is maybe set aside. People don't look at the may and they make it a shall. But I was trying to explain, Shantanu, that the process everyone will do differently. They had to put it here because the conciliator actually in the process may, but doesn't have to. And it doesn't have to be in writing. It just is how do you explain the process to people? Because here you're trying to put it in simple words for people. So just look at it from that perspective, because the user doesn't know these differences in the mediation world. We talk about models, but this part of it had to be there, because I'm saying tomorrow you can always then challenge the agreement saying, because it was the conciliator who suggested, that's why I got into it. So you had to keep everything ready, but it's a may situation. It's not the conciliation that everyone has tried to make, that it has to be an active role. But what you're rightly saying is those litigators have this in their mind. They, with their robe and the band, they'll come into a mediation. So on the other extreme, there's a mediator's interview, which I keep quoting. I don't put it out publicly, but there's a mediator's quote in India from the Supreme Court. He says the mediator will decide. He's gone to the other extreme. So those are issues that are happening in mediations, which we will never know, because the people who are part of the process themselves maybe don't know what the role of the mediator is. Yeah. So I think that part needs to be, I think it's like, for me, I'll tell you what I will, as we go along, I'll tell you how I'm looking at it. But these are things in terms of legislation. I feel what has happened is that discussion has gone into this difference. And then from that difference, we don't have a law. And from there, oh, we have to create a law. And now we'll wait for the law. So I'm saying what we already have, if it is, and I've been speaking about this two-word theory also, mediation and conciliation. The lawmakers understood the difference. Why are they using two words? Because in section 30, they've used mediation and conciliation. For me, which I've put out there, the two words mean the same. But the thing is that they had to say, when are you going out of the arbitration and when are you staying in the arbitration? Because when you want to stay in the arbitration, it's called mediation. You settle it, come back to the arbitrator, passes a consent award. When the word used is conciliation, and you say, I'm going for conciliation, you go out of the arbitration under the conciliation provisions, you settle it, that by itself is as good as a consent award, so you don't have to come back to the arbitrator. Same thing in the CPC. Both the words are used. So because when you and for there also the same thing, when you want to stay in the court and you use the word mediation, you settle, the court passes a decree. When you want to go out of the court system, conciliation word is used, you go into the provisions of the Arbitration Conciliation Act, you settle it, you don't have to come back to the court. Because we have to understand from the people in dispute also, there are costs involved for each step. To go back to the arbitrator or go back to the court, there are costs there. So it has made it so easy for them. You don't have to come back to them because it's as good as a court decree. That part has never been, I have never seen judgments really saying that so well to the people, because then the Supreme Court says, that gives all that whole thing to conciliation. Look, you have this act there. If you go there, that's as good as a court decree, nothing else to do. When they positively say that, I think that message will go down that, oh, we have a law. Because look, we also don't know how much that law is used. Maybe it's used a lot, because the thing is that no one will ever come back and say, when the settlement agreement is signed and there is no enforcement required, which also obviously should not be required, those conciliation agreements, the settlement agreements under conciliation, there may be lots of them. How are we to even say they're not there? I'm saying maybe there is extensive usage of it. So because it hasn't come to the court, because obviously if the settlement agreement has been such that everyone is agreeing to it, why do they have to come to the court? So we won't even know those numbers. So we very nicely, easily disregard that this thing is not being used. We don't know what's being used. Because so I think, say we have a provision there and we need to consider it from the point that we already have something, because bill part of it, I keep saying that's an X bill. Luckily, it's an X bill. Now it'll come back in a new form, and hopefully,
that always happens, because especially when it goes to a standing committee, and there are outside the standing committee also there are so much of comments, and so I agree with you that there are a lot of
Because I feel
But on technical side, it is still the bill that stands.
Ex-bill. Let's say ex-bill for the moment. But I'm telling you, well, look, how I look at it from the government's perspective. The Chief Justice of India sets up a committee to send a draft bill to the government. Now, first of all, I keep saying that the Chief Justice of India to get into even looking at mediation, I think it's an incorrect thing they started from. Because first of all, the processes are different. That court system to be even connected with mediation is an issue. And then you put up a committee that whatever recommendations of the committee we'll get into, because what the committee sent and what happened, of course, that itself changed things. And the committee itself is not happy about that, what we had said. But the fact that you send something, there's a pressure on the government. So I feel it was all put together quickly that, okay, judiciary is putting pressure, let's put a bill. And it was a hodgepodge. It was a real hodgepodge. And let's put everything into it. And I think things were not considered. Luckily, the standing committee.
It's a bag of everything in the bag and put it inside the bag.
Yeah. So I think it was done because there was a pressure there. And okay, that was sent. Luckily, standing committee goes to the standing committee, it sends back with recommendation. And we don't know what's really going to happen. Like you said, there's so many people who've given their own comments to it.
Outside and very relevant also. As I said, there, I mean, the qualification itself is crazy in the sense you have 4 registrations required.
Yeah. Luckily, Shantanu, luckily in the bill, at least that freedom is given for people to choose a mediator. On this other side, on the pre-litigation and that part of it, okay, maybe we'll have to look at that also. But luckily on the other side, they can appoint a mediator and the process is still theirs to that much of an extent. But I'm still going to, of course, question that pre-litigation word usage, because we have pre-institution. That part of it we already have under the Commercial Courts Act. When you say pre-litigation, are you saying that any kind of dispute is actually a pre-litigation dispute? Because there are lots of options after that. When you actually going to file something, okay, pre-institution mediation can come into play. But what stage is this pre-litigation? I have a problem with that terminology itself, because when do you say something is pre-litigation? Have I already decided I'm going into litigation? If I'm not really filing something?
As far as the commercial courts are concerned, as you very well know, that it is the moment a matter becomes contentious and you want to move it to litigation, before moving into filing a suit of any sort, you have to the first mode of the first forum should be mediation. And only after that you move in. I mean, of course, what many are doing is that it is just namesake mediation they are filing. And this is happening very much in reality. So that is what they meant, my understanding so far.
Because look, but the thing is that under Commercial Courts Act, it is understood that is pre-institution. That word terminology still had some meaning. Yeah, it still had some meaning. Some meaning there. And pre-litigation obviously moved into, I mean, look, the intention being that any dispute at any point of time, is it pre-litigation? Because that part of it, this again comes from people who are part of the adversarial system, and they are looking at drafting from that perspective. Because, but you also, why I was taking you to the village was because of this whole registration part of it. Because for me, in terms of mediator, whoever disputing parties want to make a mediator becomes a mediator. There is no one else who can make a mediator, and it's their trust in the person. On the other side, when the culture develops by itself, people will, by word of mouth, will obviously be able to talk to people. Okay, a mediator, and okay, we know so and so settled so and so dispute. Then the word of mouth happens. So I think that activity hasn't happened. There are those people haven't been brought out, which are existing. They exist, but they're not there as a word of mouth situation. The process, like this whole colonial concept mindset, the process itself, people have moved away from. So I feel it's still very early in this stage to try and get into a more advanced or more structured or maybe more complicated law. And we should never get there. I mean, my concept will always be there, but that's like tens of years away. We are at this stage that even the 1980 language of that is still language we have to explain to people. How do you do it? What do you have to keep in mind? All that is being put in this, because you're creating that awareness. So that part of it, I think we are jumping too soon into all that. And I still feel, look, for me, I will always say this, there are vested interests because they have looked at certain countries where the certain institutes that you have to go to for this institution also, you have to go to certain institutions. So we pick up from there and tell the government, look, there is this happening in the world. But when we look at the size of those countries, there might be 3 million population or 30 million population. It's not a country of 1.4 billion people. So once you say that these institutions you have to go to, what I'll imagine what you've done, that already 18 million matters who go to court. There was a Agami Niti Aayog report which says maybe 3% to only 25% go into courts. I look at the 3% part of it. So that 30 times more disputes out there. We're talking 400-500 million disputes. And to say that only a few institutes you have to go to or a few mediators you have to go to, I think we've gone, maybe not understood the whole import of the whole, I mean, what scenario there is outside. So under all those circumstances, I feel the fact that of a registration and a body like a Mediation Council of India, I mean, I tell you, the scale has not been understood. I think the scale has not been understood, or maybe there's too much pressure. And I still feel that the government maybe understands that, and people in the parliament understand that, because certification and accreditations and training on that other side do not apply to the legislators themselves, because it is a trust process. Whom do I trust to be my representative? This is also whom do I trust to be my mediator? So if the parliament, to get into parliament itself, imagine you're a body which is actually going to make the law. There is no qualification required because it is the trust of the people. How come this trust of the people has to go through so much criteria? Yesterday we had from Mexico, Rafael, he says they've tried to create so much training and training after training, and there actually so much registration and everything. It's gone into over and over legislation. So once you give them that direction, and I say there is vested interest, because training institutes are the only people who are really minting money out of it. It's a whole industry on the other side. So
yeah, I mean, the mediation is not happening. Mediation training is happening,
exactly.
and wherever you go, they some way or the other, if they have some accreditation from overseas, some institute, the mediation, the amount that you need to pay is going up like crazy.
Exactly.
So it's a business. It's very much a business.
And you're told that you'll
become. But Vikram, with that, I think we'll have
I can understand. I understand.
We'll have to close. And,
my mistake. I did not know the other person would cancel.
So this is fine. This is fine.
But Santanu, thank you very much. But
So
I'm going to get you.
Thank you.
I'm going to get you involved in the other part of it. There's a skill development aspect that I'm going to put up so that this whole thing goes there. And of course, there's a workshop on the 19th. Please drop in if you have time. So thank you very much. Wonderful speaking to you. And lots of things we need to discuss. See you.
Sure.
Bye.
Okay.